Good afternoon to everyone attending from Europe, and good morning to those that are joining from North America as well that we've seen on the list of registrations. And welcome to the next instalment of Contract Conversations. Today, we're going to look at something a little bit different. And what we're going to look at is alternative options that are available to parties who are looking to try and fund litigation or arbitration claims. The first question that Eric and I always get when we meet a client about a potential claim or defending a claim is what prospects of success do I have? But unsurprisingly, 9 times out of 10, the second question is how much is it going to cost me to prosecute the claim or to successfully defend the claim? I mean, as many of you will know, that in England we have a general rule that the loser pays the winner's costs. But even though that you'll get back most of your costs at the end if you win, we do know that the costs of funding a claim whilst it's ongoing can be a major deterrent to bringing a claim in the first place. And the good news is that these days there are an increasing number of innovative ways to fund both litigation and arbitration cases. And in many cases, you don't actually have to fund cases entirely yourself. You can share some of the risks. And so today, what we're going to look at is just some of the options that are available out there in the market and the factors that go to whether these are likely to be available to you. Before we begin, and by way of introduction, my name is Mark Davison. I'm head of international arbitration at Mills Reeve, based in our London office. And today I'm joined by Eric France.
Hi, I'm Eric France. I'm a commercial disputes partner, also based in the firm's London office, and I specialise in helping clients resolve disputes under commercial contracts.
Okay. Just very quickly before Eric kicks off, there is a Q&A function, so please do ask questions. I think we had about 200 people registered for today, so we'll try and deal with as many questions as we can at the end. If we don't get to your query, then we'll try and follow up with you separately after the session.
Okay, so first of all, one person that may be able to help fund your claim is the law firm that you instruct to bring the claim for you. So law firms, including us here at Mills Reeve, will sometimes agree to help fund a case, although this is a regulated area, and so there are some regulatory limits on the kinds of arrangements that we're allowed to agree to. But two of the main kinds of agreements are conditional fee agreements and damages-based agreements. So dealing with the first of those, conditional fee agreements, or CFAs, this is where you enter into an agreement with your solicitors that if you lose the case, your solicitor either gets paid a reduced fee if the agreement is what we call a partial conditional fee agreement, or the solicitors get no fee at all if it's a no-win, no-fee conditional fee agreement. However, if you win, the agreement will provide that your solicitors get paid their normal fees, plus a further percentage of that fee, which is called the success fee. And the success fee can be up to 100% of the solicitor's normal fee, but no more than that under the regulations. So you'll need to enter into an agreement with your law firm setting out the terms of the CFA, including the definition of the pivot. That's the event which defines success and triggers the success fee. And usually this is defined as the court giving a judgment or you entering into a settlement with the other side that's above a particular sum of money. And the law firm will generally look into the merits of the case and its chances of success before agreeing to act under a CFA, since the lawyers will want to know that there's a good prospect of success and of receiving the success fee before they agree to act on a no-win, no-fee basis or discounted fee basis. So generally speaking, the solicitors will be looking to be satisfied that the claim has at least 60% prospects of meeting the agreed definition of success in the agreement. So one point, though, to be aware of is you won't be able to recover the success fee element from the other side. That's no longer allowed. And so if you do have to pay the success fee if the case wins, you'll have to pay that yourself. You won't be able to pass that cost on to the losing side. I should add that for those of you who use arbitration, there is a slightly odd case called ESA, which Mark will talk about a bit later, where the result was a little bit different, but he'll come on to that in a moment. So the benefits of a CFA, though, include that you are sharing the risk with your own lawyers. You're sharing the risk that the case doesn't succeed. Also, though, if you choose to tell the other side that you are pursuing the case using a CFA agreement, then they'll know that you're litigating the case without having to pay your solicitors any fee at all during the case, or only having to pay them a discounted fee. And they'll also know that your solicitors have objectively assessed your case and have come, have sufficient confidence in the case to agree to act under a CFA. And the other side, knowing those things, can actually be quite a powerful psychological factor in terms of persuading them to settle a case. So turning then to the other main type of agreement, which is a damages-based agreement. Damages-based agreements operate in much the same way as conditional fee agreements, except that instead of billing you on an hourly time incurred basis, the firm simply will take a percentage of the damages that you recover if the case succeeds. And the percentage will be agreed up front in advance, but by regulation, it's not allowed to exceed 50% of your damages. And the main advantage of a damages-based agreement is that you can be sure that you'll only be paying your solicitor's costs, which are proportionate to the benefit that you yourself receive from the case succeeding. But the main disadvantage is that, particularly if the case settles at a really early stage, then the amount that you have agreed to pay your lawyers could be considerably higher than the value of the work that they've done on a time incurred basis. So, for example, if you settle a case very early on and the lawyers have only written a couple of letters, but you've agreed to pay them 50% of your damages, then they could be being substantially overcompensated for the work they've done. So for that reason, we usually recommend that if clients do enter into a DBA agreement, that it's a staged agreement where the percentage of damages that the lawyers are entitled to increases as the case progresses. Historically, law firms have been a bit reluctant to agree DBAs because they're seen as pretty risky for law firms, and largely that's because the regulations that allow DBAs have been interpreted as requiring a strictly no-win, no-fee approach, so that the law firm was required to be remunerated solely out of the percentage of damages if the case succeeds, and wasn't allowed to recover anything by way of fees if the case didn't succeed. And that's obviously quite a risky proposition for law firms. But there's actually recently been, just last month, a new Court of Appeal decision which has really shaken things up. It's called the Zuberi and Lex Law Limited, and the citation there should be on the slide. And it's a case about whether a clause that in a DBA agreement which allowed the DBA agreement to be terminated at any particular point in the proceedings, and then replaced with an agreement that allowed the solicitors to be instead from that point on compensated by way of their hourly rates, whether or not that clause whether or not that meant that the DBA agreement was unenforceable. And the Court of Appeal said that it didn't mean that the DBA agreement was still enforceable, notwithstanding that it had that clause. And that itself is not that surprising, because we would have expected the Court of Appeal to decide that. But the reasoning of the majority of the judges is actually more interesting, because at least those two judges, their judgments support the view that actually any kind of hybrid DBA is possible, so that you can have you could have a damages-based agreement, but combine that with an agreement where the lawyers are also entitled to be paid their hourly rate fees, or a proportion of those fees throughout the case, even if the case is unsuccessful. So that potentially opens the door to a much broader range of arrangements that you can come to with your lawyers, where you can agree DBAs and combine that potentially with CFAs, and it may well mean that cases that otherwise it wasn't possible to find a way of funding them, that in the future, because of the broader range of options that are that may well now be available, then more cases may proceed than once was the case. I think some law firms may still be a bit nervous about agreeing DBAs. The case that I'm describing, the Zuberi case, is still very new. There's still a possibility that it might get appealed to the Supreme Court. It could be overturned, and we haven't seen how it's going to be applied by the High Court yet. But it does suggest that there is likely in the future to be a broader range of options available to people looking to fund cases. One disadvantage, though, of both CFAs and DBAs is that they only deal with how your solicitors will be funded and how their costs are going to be met. They don't deal with how you're going to fund other expenses of the litigation, like barristers' fees, court fees, expert fees. And they also don't deal with the risk that you might have to pay the other side's legal costs if you lose. So we're going to go on now to talk about third-party funding and ATE insurance, and because they can help with those aspects as well.
So third-party funding. So if a CFA with your law firm, as Eric discussed, it may meet some of your funding needs, but if it doesn't, or as Eric said, your claim involves substantial counsel's fees disbursements or expert fees disbursements, then you might want to have a look at third-party funding just to see whether that might assist you. So what is third-party funding? So put simply, third-party funding is typically an off-balance sheet arrangement between a specialist funding company and a client, typically the claimant in the litigation, whereby effectively what the funder agrees to finance some or all of your legal fees in exchange for a share of the case proceeds at the end. Historically, third-party funding was only really available for large, what we term mega claims. But recently, as more and more funders have come into the market and there's more competition, there are some funders who are now looking at smaller claims to fund so that they can actually make a return on the funds that they have under investment. Reports conflict actually as to how much litigation funding money is out there in the market. Some reports I've seen indicate there's about $12 billion available globally, with about £2 billion available in the UK. But certainly there is a lot of demand at the moment by funders to find good cases to fund, because funds are traditionally investment funds, so they do need to make a return for investors. The big downside of third-party funding, if you haven't come across it before, in our experience, is that it does tend to be expensive. And whilst there is a lot of supply there in the market, funders do need to make a return for investors. And so the price that they effectively charge, it depends on a lot of factors, but typically funders are looking to receive a return out of the damages that's equal to about 3 times or more of what they've invested in the case. Instead of just applying that sort of 3 times multiple, they might just charge a high interest rate on the amounts that they've invested in the case. Another downside is that funding tends only to be available at all in cases where the potential damages in the claim are roughly around 10 times of what it's going to cost to pursue the claim. And so, as you can appreciate, that by its very nature rules out quite a large proportion of claims. But the reason for that is that funders only want to get involved in claims where there's a big enough pie to carve up between themselves, the lawyers, but ensure that there's still enough proceeds left over that it's worthwhile for the claimant to embark in the litigation. What we're all sort of reluctant to ensure is that there isn't what we call a bad incentives for claimants, where they might lose interest because they just don't feel that there's any skin in the game left for them, on the basis that the funders and the lawyers will take most of the upside of any damages which are recovered. There are various different types of products which are available in the market, and I've listed some there on the slide. We just haven't got enough time to sort of go through all of the options which are available there. But Eric and I would be more than happy to have a discussion with you if you're interested to know any more about the particular types of products, or if you've got a case at the moment where you're having difficulty finding liquidity to fund the claim and looking for alternative ways that you might be able to fund it. But I'll just quickly run through two. Just the most sort of straightforward, straight financing, traditional funding of claims, and then quickly ATE. So effectively, straight financing, traditional funding works whereby the funder agrees to fund a case up to a certain level and agrees to take a return on the damages which are recovered at the end. You can structure that so that only set amounts are committed at particular stages, so that if a matter settles early, like with a DBA that Eric was mentioning before, the funder only receives a certain amount of the upside. You effectively don't give away all of the upside that you've agreed to give. Before Eric just moves on to ATE, I just want to address 2 points. The first, again, is about the question of whether you can recover the success fee from the other side. Again, in the context of English court litigation, a success fee to a funder is not going to be recoverable. But as Eric mentioned, there is this slightly odd case in arbitration called SR and Norscott. And in that case, the arbitrator ordered that the losing party pay all of the winner's success fee, holding that that was so basically arbitrators got discretion to award that the loser pays other costs in the arbitration. And the arbitrator in that case held that other costs also included the success fee element to the funder that had funded the claim. The loser challenged the award before the English High Court, and that was rejected. And so the last I heard about that was in the summer last year, was that the loser was trying to challenge that award from attempts that the winner was trying to make of trying to enforce that in India. And that was being challenged up to the Indian Supreme Court. The second point I just quickly want to touch on is just about the process of obtaining third-party funding. And it is quite involved. So Eric and I have been through it several times, and funders truly want to understand what it is that they're agreeing to invest in. So generally what happens is that your lawyers will need to submit a detailed proposal about the overview of the case with supporting documents. And then that needs to be supported by an opinion from a barrister on the merits. And then the funder will review that. They may ask some further questions, and then it's put towards the funding committee to review, which is usually a team of experienced barristers and QCs. And from that, the funder will decide what terms they're prepared to invest. That process can seem quite arduous at the time, but the major advantage of that is that if you tell the other side that your claim is being funded by a third-party funder, they will know how rigorous a process that claim has been through, and that somebody has objectively decided that it's going to win and decided to put their mouth where their money is and have decided to fund it. And that can be an extremely strong incentive to encourage the other side to settle.
Okay, so turning then to insurance. If you are contemplating any litigation, it's always worth checking your existing insurance policies to see whether you have any cover that might be relevant. Cover for litigation costs is more likely if you are a defendant, but there might also be cover if you're a claimant, particularly because several different kinds of policies include some level of what's called legal expenses insurance as a sort of standard add-on. And so you may have some cover under legal expenses cover. So, but if you don't have any existing insurance, then it is possible to purchase something called after the event, or ATE insurance. And that's taken out after the dispute has arisen. And there are a number of insurers who offer cover in connection with, usually in combination with conditional fee or damages-based agreements, or together with third-party funding arrangements as well. And some of these policies will cover your own costs, but it is actually also possible to get ATE insurance, which also covers your own costs. So usually this policy is to cover the costs or the adverse cost risk, the risk of having to pay the other side's costs. But it's sometimes possible to buy these policies that also contain cover for your own expenses, such as solicitors' fees, barristers' fees, expert witness fees, etc. In the event that you lose the case, then the policy kicks in and covers you for those costs. You still have to supply the cash flow to fund those expenses during the litigation, but if you lose, the policy is there so that you're not out of pocket, even though you've lost the litigation. It's also possible to buy these policies with premium, which is called a deferred and contingent premium. And what that means is that under that sort of policy, the premium itself is insured so that you don't have to pay the premium for the policy at all. You get it for free in the event that the claim is lost or discontinued. You only have to pay the premium if you win the case. and then you can pay the premium out of the damages that you get from the other side. So as with success fees under CFAs, though, it's generally not possible to have the defendant pay the costs of an ATE insurance premium as part of the costs of the litigation. If you win the case, you instead have to pay the premium yourself out of your winnings, so to speak, or from any other funds that you have. Okay, so over to you, Mark.
So, if you do find yourself in a situation of having a claim but wondering whether it's worth pursuing, I appreciate at the moment in the context of COVID that liquidity, cash is king, is more vital than ever. But if you do have a claim there which seems to be a valid claim and you're considering whether it is worth pursuing, then please do get in touch. We routinely help clients with that sort of initial assessment of the claim, its prospects and the costs involved. And in appropriate cases, we can help you with alternative funding arrangements, whether that's by agreeing a CFA ourselves or helping you with applications to third-party funders and ATE insurers in the market. Eric and I have regularly worked with untitled brokers to try and find the best deals that are available out there in the market. If you want to know more about these arrangements, what we'll do is in the follow-up email with the recording to this webinar, we'll attach a short guide about the types of options which are available, so you can have a look at that in your own time. But alternatively, as always, please feel free to get in contact with Eric and me if there's anything which you would like to discuss. So we'll just start looking at some questions. And please feel free to ask questions using the Q&A box. So the first one we've got is with costs. I thought you would only win 65 to 75% of the cost, not 100%. That's generally right. So you get most of your costs back. As a general rule of thumb, it's around 70%. Every case is different, depending on it's ultimately at the court's discretion as to what they'll order. And usually, actually, sort of costs are usually settled between the parties as what's to be paid, so that you don't go through what's called a detailed taxation of costs at the end, which, having been through a handful, are not a particularly pleasant experience for most practitioners. I think that's probably the safest way to call it, Eric.
Yeah.
Do you want to take the one on ATE?
Sorry, I'm just trying to bring it up. Do you have the question there, Mark?
So does ATE insurer usually insist on the caliber of lawyers to give a high chance of success?
I think that who the lawyers are and whether or not they're known to the insurers is probably something that's taken into account. It's not. I wouldn't say it's the number one thing they're looking at. They're both the insurers and the funders are probably the very first thing they look at is they want to see an opinion from counsel that's assessing the merits of the case at more than 60%, at least 60%, and that's the number one thing they look at.
And then we've got one here about, will third-party funders have to pay the other side's cost if I lose? So I think in short, most likely. So I think what this is driving at is what we call the arcing cap. So basically, I think the question is, will third-party funders be liable for the other side's costs if you lose? And in short, most likely, because of this case, what was originally called the arcing cap. So what the arcing cap said, the arcing cap was a Court of Appeal case. I think it was around 2005 or so. And what it said was that a third-party funder would be liable to pay the other side's cost if the claim lost, but only liable up to the amount that they had invested. But things have moved on a lot since that case in 2005, and so where we ended up was by last year there was a case called Chapelgate, which again was another Court of Appeal decision, and what that case said was that the funder would be liable for all of the winner's costs from the date that the funder got involved. And so because of that, what we're seeing a lot at the moment in the market when dealing with funders is that there is a particular appetite for them to ensure that there's ATE policies there as well if they're going to decide to fund a claim.
Okay, so somebody has asked here, can conditional fee agreements be used by defendants? Yes, they can. It's not as common as with claimants, and you need to come up with a definition of success, what I described as the pivot. But success can be defined in terms of, for a defendant under a CFA, success could be defined in terms of avoiding liability altogether, or alternatively reducing the damages, the quantum of the damages claim that the defendant's liable for to below a certain figure. And if you can define success in that way, then that could trigger a success fee for the lawyers.
Just given the time, I'll take this final champty question, Eric, and then let's wrap it up. So this question is effectively, why is third-party funding not deemed champty? So that is a good question. For those of you that might not have heard of the terms of champty and maintenance before, it was basically, it's an offence for third parties to get involved in somebody else's litigation, usually by funding it. It was a crime until sometime around the 1960s, but the sanction now is that somebody else can fund the litigation, but if it's deemed champty or maintenance, that arrangement will be deemed unlawful. And traditionally what happens is that effectively if you win, you won't get your legal costs from the other side because that champtus arrangement was deemed unlawful. But in the context of third-party funding, it isn't champtus, and that's basically because third-party funders don't get involved in running the case. They effectively treat the claim as an investment or an asset, but don't actually get involved with how the litigation is run. And there was a speech in around 2012, 2013 or so from Lord Neuberger, where he was talking about the importance of third-party funding, and that in fact actually it's a really important tool as to allowing access to justice. So in short, provide the third-party funding is structured correctly, and that the third-party funder doesn't get involved with running the case, then it's not a champtus or maintenance arrangement. Okay, I think given that it was sort of 28, 29 minutes past, I think, shall we wrap it up there, Eric? But there's details there on the screen. I appreciate it might be covered up by the cameras of Eric and me, but with more details that you can find about funding legal proceedings on our website. What we'll do is, as well, after this seminar, we'll send a recording of the webinar as we usually do, and we'll attach a short guide as well about alternative options that are available out there to help you fund legal claims. But in the meantime, thank you very much for attending, and have a good afternoon. Thank you very much.
Thank you very much. Thank you.